biased and prejudice mean? That just really means that bias tends to be a positive connotation, that you like someone so much that you would just say yes to whatever they're asking for. And prejudice is the opposite, that you dislike someone so much you would just say no and you wouldn't matter what the evidence was. And so the key question for all of the members of the Plan Commission is very simply, can you be impartial? If you can be impartial, despite the fact that the petitioner lives 3 houses down and you may have gone to a cookout at his house once, doesn't matter, as long as you could be impartial and do your job. And I often get that question from members of the commission. They'll say, well, look, I know that person. Does that mean I can't decide? And I'll say, well, do you think you can be impartial, hear the facts as are presented and decide? And if they say yes, then I say, well, then go ahead. And if they say no, then we ask them to recuse themselves. Any recusal has to be a matter of the record. And if you know about it in advance, you should let the zoning administrator know. Now, what is a conflict of interest? I would say it sounds easy, but not quite so. So what the courts have said is that a conflict of interest involves a financial interest in which you or a family member, a member of your immediate family, has a direct or indirect financial stake in the outcome of the case. There's one case where they tried to see how far that went. Perry Worth Concerned Citizens versus the Board of Commissioners of Boone County. And in that case, someone raised the issue of conflict of interest because the Plan Commission member's wife owned a 1/5 interest of the property adjacent to that which was requested to be rezoned. And so nobody knew, but the court said that's not enough. If it had been the property to be rezoned, well, absolutely, that's a conflict of interest. But just because an immediate family member owns property in the vicinity and might be affected is not what we mean by conflict of interest. It is, as you can see in the Fail versus Laporte case, unnecessary to show that the conflict affected the vote. A conflict of interest absolutely negates the partiality of the member, and therefore it could invalidate the decision. So we don't have to show cause and effect. We just have to say, if you have a reason, if you have a conflict, you have to not participate. If you look at page 6, you'll see, how do we know? And again, the ways that we know are usually one of 3 things: personal relationships, or a statement that is made by you about how you feel about something. And lastly, close personal relationships, obviously. What I found in my experience is that it's usually statements that people make about topics. And if you're in the Plan Commission, for example, you should never make a statement that you would never approve apartments in the village. You might or might not do that, but never means you wouldn't consider facts that were before you. So that's an example. Acts by the commission, as you know, I think you need 4 members to have a quorum and 4 votes always to take action. Now, what are the types of cases heard by the Plan Commission? I break them down between discretionary cases and non-discretionary cases. So discretionary cases are rezones, PUDs, and text amendments. And in those cases, you and the town council are free to use wide discretion in what you think is right. Okay, those are considered legislative acts, and the courts have said they won't get involved with legislative acts unless we just ignore the facts and act arbitrarily and capriciously. And I'll talk more about that later. No discretion. Ministerial decisions are plats and DPRs, development plan reviews. And those are cases in which, if their proposed plat or DPR, development plan, meets our code, then it should be approved. Some discretion, a third category, is where there's a request for a waiver or a condition. So the petitioner is saying, well, look, it doesn't really meet the ordinance as long as you give me this waiver. Well, when that occurs, now they're no longer ministerial. Now you have some discretion, and you have discretion as it relates to that waiver or that condition. As you see in the middle of page 7, rezones are the most important and difficult cases. There are 5 statutory criteria that you have to know, which I know that you do know, but no one has a right to a rezone. Okay, if someone comes with a plat and it conforms to our ordinance, they have a right to have that approved. But rezones are discretionary. So you can see you are supposed to give due regard to the comprehensive plan, the current structures and uses in the zoning district, the most desirable use for the land, the conservation of property values, and responsible growth and development. Now, the courts have said that no single factor carries the day. And especially in the first 20 years of under this statute, we had a lot of cases where they said, look, they granted a rezone, but that's not what the comp plan said, so it must be invalid. And the courts again and again said, well, we disagree with your analysis. Okay, the rezone that is approved, if the other four factors weigh the other way, weigh toward granting, then the fact that the comprehensive plan says something else doesn't end the day. Okay, so you have to balance those five factors and again, reach your decision as to what you think is right. Responsible growth and development really focuses on things like utilities, transportation, schools, and things of that nature. You'll note in the bottom of the page, the reference to the Borsick case, which is the leading case in this area. And in that case, the court went well beyond what it normally would say in order to make a point. And it said, look, rezones seem like planning and zoning, but they're really legislation. And because they're legislation, we are not going to peek under the hood very much. We're going to let legislative bodies do what they can unless they're arbitrary, capricious. So unless they get away from the facts or don't consider the facts, then we're going to let that be. And the Borsick case went on to say, and every case since then has said that what the court's going to look at is whether you deliberated about the five factors. And I have some commissions who will sit there in every rezone and say, okay, let's take the five factors. Number one, what does the comp plan say? Number two, what are the current structures in use? And they discuss them. Or they ask questions of the petitioner, which is a great way to make findings. Or they ask questions of staff, which also is a great way to make findings. But they touch on all five of those. And that's what I think is the best practice in your cases. If you go over to page 8, there's a discussion of planned unit developments. And again, as I said earlier, that's just a rezone with extra criteria. The key thing about a planned unit development is that we allow the developer to write their own zoning ordinance. And that's why they deserve so much attention. You see on page 9, number 6, you'll see that because of that, I think you should be very careful and review the ordinance, the definitions in the ordinance, the setbacks. Now, in general, what we would like to see is we would like to see the PUD ordinance be more strict than our ordinance, not less strict, more strict. That's what we'd like to see. And often they are. But again, I would invite you to pay close attention to the actual proposed ordinance. And that's where it's where it becomes a little different from a rezone. Because in a rezone, the petitioner, the developer is stuck with our ordinance, but in a planned unit development, we allow them to write their own. Text amendments on page 9, I just mentioned that there are many reasons why we would do text amendments, but the best reason to me is when planning staff and the commission or the BZA keep coming up against the same issues, and it's obvious that we either need to change that or massage it a little bit because we're seeing constant variances from the same thing, for example. So the BZA members, you're one of the great sources of information about what should be changed in the ordinance, in my opinion, because you're the one who keeps getting asked to ignore the ordinance. And if it's something you keep approving and you think it seems better that way, then those are things we might change. If you would turn to page 11 with me, what you need to know, special issues, you'll notice there's a discussion about findings. And in those findings, number 3, you'll see again what I said earlier, which is to make findings, you need to deliberate, ask questions of the petitioner, ask questions of the staff, and make sure that you deliberate or discuss each factor. The courts have said that just reading the motion the staff prepares for you and having no discussion is not good enough. You actually need to discuss those things. So I can't emphasize too much how important that is in the deliberation of your cases. Waivers, you guys do a good job with waivers, but again, nobody has a right to a waiver. And so look at the staff report. It will lay out the staff's analysis of that. And the rule that I like to use is if it makes the development better, okay. If it doesn't, then no. I mean, it's just really what it comes down to. Remember, as you see on page 13 at the top, you make the motion on the waiver first before you make a waiver on the case in chief. The next topic is the open door law. And the open door law generally allows citizens to attend and record meetings. What the big question is, what is a meeting? It's not very well understood what a meeting is under the open door law. It's not what you would think. So if a majority of members of the commission or the BZA are together and they are taking official action, then it's a meeting. So if you go to page 14, you'll see under item 4, a list of what taking official action is. It is receiving information. That's the one that gets me every time. Just listening, that's a meeting. Deliberating, that sounds like a meeting. Voting, that sounds like a meeting. For planning commission members, you have an exception to the open door law, which says you all can get in a van and go to the project site if you want and look at it. You can. That's really different. But it's really important to understand that with the word meeting being defined in that way, that it's probably more than you would think. Even if you don't talk to each other at all, if you're just receiving information, that's a meeting which has to be open to the public. Now, email is I often get questions about email, and email is not necessarily a meeting. The Public Access Counselor has said that email is like regular mail. It's not simultaneous. It isn't really like a chat room. And so although you can email without it being a meeting, a couple of pointers: you should avoid group emails that include a majority which request a poll. How do you feel about this? Don't do that. Also, don't participate in emails where asked how you might vote. Those two things, again, take it from something that's okay to something that's not okay. Also remember that any email that you send to each other or to staff are available to the public. So I always say that unless you would put that email, tape it to the front door of the town hall, don't write it that way then. Okay, be careful with your email. Now, if you'll turn to page 15 for me, I just want to talk for a minute about the Religious Land Use Act. It also applies to prisons, but I'm probably not going to touch on that part. But it's a federal law that applies to both the Planning Commission and the BZA. And that is when you have a religious organization be the petitioner in front of you, you have to treat them just like any other petitioner, regardless of their religious status, religious practice, or beliefs. And I always say, just treat them like a commercial or institutional use. Avoid religious issues or discussions. And there's a famous case out of Colorado, the Rocky Mountain Christian Church case, in which the president of the Planning Commission, who really didn't want this mega church to be built, not only told everybody, all of his friends at the coffee shop, but also started asking them questions about their religious beliefs during the meeting, which of course was an indicia of he probably cares about their religion a little bit, and we don't want to do that. So our big thing is we have to show that we're not biased, that we're going to treat them just the same as everybody else, regardless of the tenets of their faith or denomination. If you'll turn next with me over to page 19. Just want to remind you that it's the petitioner's job to present the facts to you. The petitioner's job to present facts that would weigh in favor of granting a rezone. And so what I've done for you there is I've given you just questions you can ask. If someone, if you don't think one of the factors are met, try to get the petitioner talking about that. So for example, if it's inconsistent with the comp plan, you would ask, why would this be in the best interest of the town? Maybe it is. Maybe it's better than what the future land use map shows. But the big thing is drawing that out of them. And I've included one for each of the 5 factors for you. Other best practices on page 20. Once a year, I'd recommend you kind of skim through your ordinance. And I know it's big, I carry it around, it's heavy, but I do think it's worth just kind of reminding yourself once a year what's in there. It's easy to forget. carefully read your case reports. Your staff does a great job with their staff reports. And they not only give you the underlying facts of the case, but they also kind of tell you what the issues are. Hey, here's what we're concerned about. Here's what we'd like you to be concerned about. And so that they just provide you with a roadmap. And in a recent case, the court said that when a member said, well, in the case report, I noticed that this was a concern. And that was one of the factors the court looked at to show that the members had deliberated on all 5 factors. Again, just a reference to the case report. Also, consider writing questions before the meeting. Okay, when you're going through the case report, you might just jot down, I'm going to ask the petitioner this, or I'm going to ask the petitioner that. It's sometimes, some of you are really good at doing that on the fly. For some, it might be easier to jot them down in advance. Don't be hesitant to vote no. I will tell you that what I observe in representing multiple plan commission is there's one commonality, and that is that when you have a bad proposal come before the commission and you really don't like it, instead of just making a motion and voting no, you talk it to death. And everybody does this, so I'm not picking on you, but you start talking about all the reasons you don't like it. And sometimes it's best just to make a motion and just get that off your plate fast rather than be tortured by it. Okay, and that's what I've seen. Don't redesign the project. It kind of is what it is. It's the petitioner's job to design their project. So let the case stand on its own. And for recommending decisions like rezones or PUDs, and you guys do a pretty good job of this, but include enough in your findings or your discussion so the town council knows what you're concerned about. When the town council gets that certification of your decision, if they look at the findings and they can see specifically what you were concerned about, then that will help them. And they defer to you a great deal. And I know that I get asked a lot by town council members, what was the plan commission concerned about? Here's what they were concerned about. And they really want to know because they really rely on you to do much of the heavy lifting. And they know that you know more about planning and zoning than they do because you really dig into it here. So state your reasons of your concerns, especially if you're giving it an unfavorable ruling. On page 21, allow public comment. Don't engage. The citizen has a right to say what they'd like, even if you think it's silly. Thank them and move on. Consider what they say, but it's not an argument. So just allow them to say what they'd like to say. Okay, I'm going to switch gears now to the BZA. And on page 22, we start there. You'll note that the BZA is considered to be a quasi-judicial body. What the heck does that mean? That means that you're like judges. And along with that comes some special rules. Your job is just to, on this pretty narrow window of an issue, just apply the local ordinance to the facts as best you can and make your decision. You are not allowed to talk to the parties or members of the public about the case. You're not allowed to visit the site. You're not allowed to be policymakers. Even if you think the ordinance is not a good ordinance, you're stuck with it. So you're a lot like an umpire on balls and strikes. You see it come in and you make the call. That's that. Quasi-judicial, very different role than plan commission, but very important. And BZA makes really important decisions. If you think about it, the 3 things you decide, administrative appeals, variances, and special exceptions, are all things which say, let's just set aside our ordinance here a little bit or decide what it says. So administrative appeals are filed when a member of someone decides that they think our staff is interpreting the ordinance incorrectly. And although these are rare, they are really important. Sometimes the language of an ordinance isn't very clear and the staff has to make an interpretation. When that happens, a party could appeal and then the BZA decides what our ordinance says. That's a pretty important role, what our ordinance says. Secondly, on variances, when you determine a variance, you're determining what flexibility the town should give to people who do not want to or cannot comply with the ordinance. Again, I would say pretty important. And then lastly, special exceptions. And special exceptions are uses that are peculiar or might have a great impact on neighbors. And so the town council has decided that if we're going to allow any of those kinds of uses, we want to make sure somebody takes an extra look and tries to make sure that we can, if that's approved, that it's approved with conditions that lower the impact. So it's a very, very important thing. Yes, Chris.
Can I back you up a minute on number 3, no site visits or investigations? That is as a group. Correct?
Sorry?
That's as a group,
Correct.
not individually.
Correct.
Okay.
So special exceptions, what could be more important than that? And you'll see later that, I think you'll see later just how important that can be. If you'll go with me to page 24, get into each type of use. Variance of use is very unusual. Variance of use is usually a case where something needs to be done to allow a use that's not allowed in that district. Now, the petitioner could file a rezone, but the variance of use is thought to be more efficient, especially for smaller properties, because it allows the landowner to have that use without rezoning the entire property. It's very important, and they're very specific criteria. The thing to remember for variances in use is they are discretionary. So you see on page 25, I emphasize this a lot, discretion. Even if the petitioner can satisfy all of the statutory criteria, it's still up to the BZA to decide whether that's best for Zionsville. And that's what that's really all about. Okay, this is not one of those where in both types of variance cases, variance in use, variance from a development standard, discretionary approval. So again, I'm a big advocate for the BZA being important, and this is just a good example why. Discretion, some petitioners will stand right here and tell you they meet all the statutory criteria, have to grant it. Nothing could be further from the truth. So remember that. Same thing on variance from development standards. As you'll see on the bottom of 25, when the landowner can't comply with the standard, they can come and ask to basically be relieved of that standard. You see a lot of these with setbacks, building height, building materials, could be anything. But on these are the much more common type of variance the BZA hears. And again, you'll see on 26, these are discretionary also. Now, special exceptions. When are they required? They're required whenever the use table says for a particular use, it has to have a special exception. So if you look at your use table, then there's an S there. That means special exception. I've listed just some. There are a lot of cases, but usually they're the types of uses that concern us or make us think about impacts to neighbors. And so animal kennels and animal daycare is a good example of one which requires special exception. And in those cases, we're going to be concerned about how far are you away from the neighbors? What will they hear? And so you can see that for small uses, those are often common. On larger uses like solar and wind farms, they usually require special exception as well. And you would know why. But so you can impose conditions on those. There is statutory criteria which really requires first to be listed as a special exception, and then all the other criteria really all about impacts to the neighbors and the comp plan. Now, there's no presumption of approval. Just because it's listed as a special exception, that doesn't mean that if somebody requests it, you have to give it to them. They still have to meet the statutory criteria. But unlike variances, if they meet the statutory criteria, you are required to grant that. You are. And so it's different from variances in a pretty important way. Okay, if you'll turn to me to page 28. Again, just some best advice I have for you. As BZA members, same as the Plan Commission, read your ordinance occasionally, pay close attention to your staff reports, prepare questions in advance, ask questions related to the findings, act like a judge. Otherwise, you can only consider what you hear in this room. You can't do your own research or find anything else out. And then just like the Plan Commission, you also have a disqualification rule. If you are biased or prejudiced or otherwise unable to be impartial, or you have a direct or indirect financial interest. Our LUPA, the Religious Land Use Act, applies to you also. And so I just make mention of that. So if you have a case involving a church or some other religious organization, treat it just like it's a school or a hospital coming before you or commercial use. I'm next going to get into vested rights, common issues, and vested rights are not something you hear a lot about, but they're important. And I'm going to try to give you an introduction tonight on that in case that issue arises. And the issue did arise last year. So the concept of vested rights is grounded in the constitutional guarantees under both the United States Constitution and the state constitution that property owners can't be deprived of their property rights without just compensation. And so the debate began over when do landowners get those rights? Do they have them at the beginning of the process or later? Most landowners and most developers traditionally took the position that as soon as they started spending money on a project, they had vested property rights. And there was no court in the land that I have found that would agree with that. But all of them said the federal courts, which are a little more broad than our rulings, kind of said, yeah, there has to be some time between the beginning of the process and the permit. Everybody agrees when you get a permit, that sounds like you've got a vested right. So the federal courts have never found a property rights claim that started before a permit, but they've said there may be some period of time where the developer has invested so much money, they gain this. Now think about a rezone for a minute. A rezone, the developer will go out and either acquire the land or an option to purchase the land. They'll spend a lot of money on design and architecture and roadways and stormwater drainage, and they'll start spending money pretty fast. But again, when do they have a vested right? Not just when they're spending money. The courts have felt something else has to happen. Well, then our legislator thought our courts got one wrong, and so they passed Section 1109 in the land use law, 3674-1109, and it said that the time in which people get vested rights is when they apply for a permit. Now that sounds really easy, except it's really not. Okay, we all know what that means. Apply for a permit. Well, the first problem is how they defined permit. So the three that you would think they meant would be an improvement location permit, a building permit, or a certificate of occupancy. Those things sound like permits. But the legislature also said if they get a development plan, it happens before you get a permit. If you get a development plan, then you've got vested rights. If you apply for it, even if the Plan Commission hasn't approved it. What else? A plat, primary or secondary plat. So somebody, again, they don't have any permits, but they have applied for a plat, then they have vested rights. If they've applied for a special exception, then they have vested rights, just applying for it. And finally, if they filed for approval of a PUD. So what permit means for vested rights is different than how your staff would think of permits, or I think of permits, and how you may think of permits. It's much broader. So why is this such a big deal? Well, whenever you adopt a new UDO and you're considering a new UDO, you're going to have this transition where you have to figure out which law applies. Okay, which law applies, the old ordinance or the new ordinance? In addition, like last summer where we had a potential change to the comprehensive plan regarding land around the airport. And you might remember there was a case where the landowner applied for a plat before the town council adopted it. And that lawyer was smart, because that meant he had vested rights, and whatever happened later would not affect his property, his client's property. So that was a very smart thing. He wrote me a very, I will say, diplomatic letter about what we were about to do. And so we had a discussion of that. But again, it gets to be really important when you have new ordinance, new UDO, any other new thoroughfare plan, new comp plan, what law applies. Now, there are some limitations to this. Their vested right lasts they get the same ordinance for 3 years. So they can't just get the approval and do nothing. They have to keep moving forward. And then they have to complete the project within 10 years. And you all, I know you're all very experienced, sometimes it takes a long time to finish these projects. And so, but this issue of vested rights, the legislature has really taken it away from the courts and said, we think that this is how we should do this. And thus far, the courts have said that the 1109 is valid, and that's a good way to do it. Okay, if you go with me to page 31, homeowners association covenants. I know you hear a lot about these. And so I'm just here to tell you, the courts have said that's beyond the scope of our authority, is that those private covenants are not included in the land use law. There's no mention of those in the land use law. And so when that issue has gone before the courts have said, we didn't tell you that you could mess around with that, so stay away from it. So again, that's something we've talked about lately, something a lot of your neighbors will talk to you about. But again, remember, where I live, we have covenants. I can enforce those covenants against any landowner in that subdivision, as can the HOA. So it isn't like there isn't someone who can enforce it just because the town's not supposed to. In the middle of that page is comments. Just remember refrain from making comments on social media about how you feel about certain topics. And then form-based codes. I know you're going to be talking about that and you've heard a little bit about it. I've just given you some information that you can read on your leisure about that. Now I'm going to talk a little bit about new cases, and the first one is on page 33, the Stiller Properties case out of Floyd County, BZA. And in that case, there was a Dollar General store going in. You'll find by reading the cases, everybody hates Dollar General. They do. The smallest Dollar General store allowed is 7,500 square feet. In Floyd County, the ordinance said nothing bigger than 5,000 feet. And so they asked for a variance, went to the BZA, and the franchisee explained to the BZA that the smallest building he could build would still be a franchisee with 7,500, and that some of the older buildings in this neighborhood before the ordinance was adopted were well above 75,000 square feet. And so it really wouldn't be a big deal. The BZA approved it. And in that case, again, the court said, well, did the BZA have a rational basis? Did they talk about impacts on surrounding properties? Did they talk about how big the other cases are? Did they talk about traffic? And in this case, the court said, yeah, they talked about all that. They're fine. That's their discretion. They did it right. And so that's a good case for the BZA members to kind of see how you can win one here and there. If you go to page 36, there's a series of cases I'll hit pretty quickly. The first is the City of Austin case number 13. And this was a U.S. Supreme Court case that dealt with digital billboards. And digital billboards, as you might imagine, and you've been up and down I-65, you know, they're big money. And so the City of Austin passed an ordinance that said, we don't allow off-premise signs. We allow on-premise signs, but no off-premise signs. So the Reagan National Advertising of Austin, LLC, filed suit against them saying, well, that cannot be constitutional. You allow digital billboards to be on a property where promoting its own business, but you won't allow an off-premise sign promoting some other business. That can't be constitutional. The Supreme Court says it is constitutional. It really is. And so that's again, a rare win for the governments on sign cases. Number 14, Becerra versus Town of Brownsburg is an interesting case to me. Now, it's a memorandum decision, and what that means is that the Court of Appeals the Court of Appeals did not consider it to be so broadly important that it needed to have presidential value. But it's a great case for training, because in this case, this was a development on Ronald Reagan and 400 North and near Brownsburg, north of Brownsburg. And the remonstrators, not the petitioner, the rezone was granted by the town council, and the remonstrators appealed, which is very rare, I would tell you, very rare, primarily because appeals are so expensive. But in this case, the remonstrators appealed, and they said that that the town made a decision that's arbitrary, capricious, that there was a residential neighborhood just west of this site, and there's no way that should be approved. And again, Court of Appeals said, well, what did the town council do? And he found that they discussed the 5 factors, they deliberated, they listened to what the remonstrators said, they looked at their case reports, and the Court of Appeals says, well, even if you disagree with that, you can't say it's arbitrary and capricious. The question for the courts is not whether it's a good decision or a bad decision. It's did you follow the proper process and consider the right things? So I like that case because of the way they talk about, yeah, that's just exactly what we've told you this before, and we're going to keep saying, well, there's a case that says the same thing. The Maryville case, number 15, which is Maryville BZA case, I also like because it involved an issue you hear a lot about, and that is if you grant this variance and allow this type of business, it's going to harm other businesses in our neighborhood. This case was a self-storage case, and a neighboring self-storage operator remonstrated and said, look, we're already oversaturated in Maryville with self-storage, particularly in this area. And if you allow this to come in, some of us are going to go out of business. And the court took the opportunity to say, maybe it's first time as I can tell, to say, look, it's not the BZA's job to eliminate competition. In fact, competition is good. And that's not one of the purposes. And to make sure that everyone understood why, they looked at section 601 of the zoning law where it says what the purposes are. And there's a whole bunch of things, and I've listed them for you there in the case summary. But what is not listed there is protecting people from competition. And so that was an important case. Posey County BZA versus Collins, number 16 is interesting. You don't see this very often, but what happened was the petitioner came in, his case was called, he said, hello, how are you? And he sat down. Then there were some people in the public who stood up and said, this is a terrible idea, don't grant it. The BZA denied it. He appealed after not saying anything and said, the BZA didn't disprove my case. And the court said the BZA doesn't have to disprove your case. You have to put forth evidence to them, and then they can hear what the public says. And the public raised some concerns. The BZA shared those concerns. They had a rational basis. You lose. I haven't seen one like that very often, but that was an interesting one. And then lastly, the Mammoth Solar case, which was a very surprising result. It involved a industrial solar development up north in Pulaski County, I believe. And in that case, when the petition came to the staff, there were 7 criteria that they had to meet. And the petitioner didn't offer anything on 2 of the criteria, just didn't offer anything. And the staff went ahead and recommended it for approval. It was approved as a special exception. And then the remonstrators appealed and said, look, they didn't even present any information on these 2 criteria that are required by their ordinance. How can we as the public prepare for a meeting where we don't even know what's going to be said about these 2 issues? Of course, nothing was said about those 2 issues. And I think a thoughtful ruling, the court said, you know what, the remonstrators are right. If you say in your ordinance, these are your criteria, you have to enforce your own criteria. And people have the right to expect to know how they're going to remonstrate by the submissions at the time of the application. If they want to go look at that, they have the right to see that. And lastly, before we get to questions, I just want to make note of one open door law case on page 38. And again, the BZA here, you guys are pretty active this year. This Posey County BZA case. Now, I've talked before about the open door law. Well, an exception to the open door law is you can go to executive session and you can discuss litigation, strategy for litigation. So in this case, what happened was the BZA made its ruling down in Posey County, and the losing party appealed, and the trial court, which is where these cases go, Posey County Circuit Court, agreed with the remonstrators. And the BZA was hopping mad about it, and they decided, by golly, we're going to take this to the Court of Appeals. We've got our training. We know the cases go up there. So in executive session, that's what they decided. And they never spoke about it in an open meeting. And the court said, well, no, you can't do that because you apparently voted to appeal the case, and you never did that in a public meeting because we looked at your minutes. So you must have done it in executive session. That would be a violation of the open door law because you can't take votes at an executive session. You also can't take official action, and that's official action. The court reiterated they could have discussed appealing it all they wanted to. And then they would have to still go out into the meeting room like this and make its decision. I'll be happy to answer any questions you would have.
That's very thorough. Thank you.
So we have from the Plan Commission a 5-year sunset on items that have no activity occurred. So because that's greater than the 3-year requirement on vested rights, it's okay. Is that the justification for that?
I don't know what the justification is, yes, but I'd say, yeah, it's okay.
Okay.
Yeah.
I mean, so as soon as they start, because I'm trying to recall exactly how we've got that drafted. It's material activity on the property, I believe. Is that once it starts, is that, I mean, do you guys remember exactly what our intention was on that one? It was before you, I know you were on the.
About the 5-year sunset?
Yeah. I think if it sits idle for 5 years with no activity, it sunsets. But we've called it material activity. So would that be contra to the vested rights?
It could be, yeah, it could be if they wait until pretty late to commence. They have up to 10 years to do it, which is different than your ordinance, and 1109 is going to control that.
And then part of that we didn't actually have a sunset
We did
ordinance.
not, because this came up with that, basically it was the Hampshires.
Yeah.
Because that was approved in 2003 or something like that. So I think that's what it was.
One
That sat idle for all those years.
Yeah. So did we actually get a sunset ordinance?
Yeah, we do have one.
Okay. I was going to ask about notice requirements, both for Plan Commission and BZA. Are they the same? And I'm just used to City of Indianapolis things where sometimes it's within so many feet, sometimes it's within so many adjoining or attached properties, and then there's also public notice requirements. I'm just trying to clarify what ours are, and are they the same for Plan Commission and BZA activities?
Requirements are 1 adjoin or deed. So, and if you were to stand in the middle of the property and do a 180, anything that touches that property, and for additional coverage, we always say across the street as well.
So what happens if the only adjoiner is a property owned by the petitioner?
If it's the same ownership, you have to skip that property and go that one deeper.
And that's for both Plan Commission and BZA. And then what about the public notice piece?
But I don't.
Signage, isn't there a certain?
Yes, that was originally, that was just added on into the rules of procedure. Very recently, that a couple of signs must be placed on the property, very similar to what your public notice is for the newspaper, say 10 days prior.
And then maybe this isn't the appropriate venue for this, but I was just kind of going through the PUDs, planned urban developments, when it comes to architectural review and enforcement. You know, once we've created a PUD, we seem to also lose the ability to have any kind of enforcement of architectural review, because it gets turned back over oftentimes to the developer.
Depends how it's written.
Yeah.
So the question I had on that with most, I mean, even this goes back to some extent homeowners association and their covenants. So in this recent one that we had, it became clear to me that even if you go to the HOA for approval, if it's a variance to the PUD ordinance, you still have to go to the town or to the BZA to get that approved. So in that case, you'd have to do both. But you can't rely upon the HOA decision when the BZA makes their decision.
Right, because one of the assumptions that one might make is that the HOA would act lawfully, which is one of the public policy reasons why I I think it's just another problem is that what if they just say no? They don't grant a waiver or an exception, and they should, even under their own ordinance or under their own covenants. What if they don't? We don't want the town to get dragged into that. But, and Larry, you're right. That's why I say pay close attention to what the PUD ordinances say about all aspects of what's going to happen later. And they even, Janice and I worked on one where the definitions or lack of definitions created a big problem for us in even interpreting what their ordinance meant. And so, your ordinance has probably 200 definitions. And so, we need to pay close attention to all aspects of that. We're giving up a lot when we say, just go write your own ordinance. Ignore our zoning or our UDO. You just go write your own ordinance. And again, it sometimes you get great projects out of it. But again, I think the Plan Commission's job is to carefully scrutinize that document as carefully as you can.
Dan, in the BZA, the considerations or the criteria we use are in many cases, I think, left to the individual as to how they feel about what is an unnecessary hardship, et cetera. And there are other times when I think that it's real clear that what's being requested makes all the sense in the world when we go right through it. We may not talk about any of the criteria that are required. But I guess what I see here in all these kind of example cases you give is that one of the certainties is if you discuss them and consider them, even though there may be difference of opinion among BZA members or Plan Commission members, that you're better off having done that than not.
Exactly right. Yeah, and I think the BZA does a great job of really trying to take that overarching approach of, is this really good for the town? Will this be a better project? You guys do a great job of that. But yeah, it's good just to touch on them. And then also you heard me talk about, unnecessary hardship is really people will not be very consistent in what that means. But the courts have really said, that compliance, if compliance changes a building or makes it smaller, whatever, that's unnecessary hardship. And it doesn't matter whether the guy should have known, which was a big argument for a long time in these cases was, well, our ordinance is public and you should have known that you can't have you can't have a 10-foot setback in the back because there's a gas line running through the front of your property. And I had that case once. And I would make the argument that no. The unusual circumstances is exactly why the BZA exists. Exactly why it exists. We've got some unusual circumstances here. How can we make this work? As long as it's a good project or, something that we think is good, then, we might grant an exception to that. We call them variances, but they're exceptions.
So the BZA has greater discretion, obviously, than the Plan Commission. And so the Plan Commission, we've granted variances for, I'm not going to go into which ones, but there's some that just repeat periodically. I can think of when they're on well and the exception for the fire. So when does a precedent become really a standard?
Well, it doesn't on variances because it's a case-by-case basis. We don't have to worry about that. But this repeated request for the same variance is when we need to have a discussion about whether we need to change our ordinance so you don't have to get a variance. Now, it may be, and I've seen these, it may be that even after a thorough discussion of you say, no, look, that's really important and we need to keep that. But other times I've drafted text amendments to kind of get rid of the difficult problem that was really the last 7 variances requested the BZA. And we see that multiple times. We need to look at it, but no presidential value for variances and special exceptions. Those are all case-by-case basis. So unlike you, they can be a little, they do have a little more free reign, especially on variances. Hey, thank you very much. We've got a Plan Commission meeting in 5 minutes, but thank you very much for your attention.
Yeah, thanks a lot, Dan.
Thank you.
to the training program. Can I take roll real quick for both committees for the record?
Oh, sure.
Okay. Sharon Walker. Jim Hurst.
Present.
Steve Mundy.
President,
Mary Grabianowski.
Present.
Chris Lake.
Present.
Cindy Madrick.
Present.
Larry Jones.
Present.
Dave France.
President.
Andy Patel.
President.
Thank you.